Leaders on Privacy First, a school's guide to the Digital Personal Data Protection Act. So we Masterclass, Dr. Aruna Sharma, who is the former Secretary, Ministry of Electronics and IT in Government of India and an advisor to INDISEC. With her vast experience in digital governance and policy implementation, she brings unparalleled insight to how institutions can adapt to the evolving framework. And then we have Mr. Anup Bhasin, who is the co-founder and CEO of INDISEC, front of helping organizations strengthening their data protection strategies. Conveying this session is Ms. Aparna Mitra, who is the privacy and data protection professional at INDISEC, and Mr. Ankur Singh, who is the data protection and privacy lawyer at INDISEC. So please join me to welcome all these experts and conveners through the importance of timely masterclass.
Good afternoon, ladies and gentlemen. It's really a pleasure to interact with you out and awaiting the rules to come. And what we have learned from your very senior colleagues is preparation is half winning the war. So that is what we have been taught by teachers like you. And today you are gearing yourself for the same. So let me welcome you on that note. I'll give you a little bit of background before my colleagues tell you the finer details. That why did government think of data privacy? Because suddenly India moved into digital India, and a digital footprint of every data or every action you are doing into your personal lives. So whether it is you are shopping through e-commerce, or whether you are feeding your data, you are storing your documents, or whether you are interacting with anybody. The same shifted to the schools where digital became an important tool for teaching, the way you teach, the way you store the data of your students, the way you interact with their parents, and also when you move ahead, when you work with it. So this kind of a data pool, or what you call, has started coming, and it was becoming like a data swamp. And free internet across the globe, which has no geographical boundary, was the problem area. So under this problem area, it was very badly hit, and therefore we had, by the Supreme Court of 2017, what you call it as a Puttaswamy's judgment. At that time, Aadhaar was made for all 100 billion population or the adults above 5 years of age. And while making the Aadhaar, everybody became so excited, they started using Aadhaar everywhere. Even the government thought Aadhaar can be used everywhere. But the Puttaswamy judgment said no. It's a private data. It has to be with consent. So the factor of consent came out very strongly. And it made it very clear that till you have a consent, you cannot use. So the landmark judgment was 2017 Puttaswamy judgment, where it said, and accordingly, it was used when we made the act for Aadhaar. So in making the act for Aadhaar, Section 7 covers the entire consent upon it. That only when the government is giving some benefit, you can insist on identifying. What is Aadhaar? It's identification. Nothing more than that. So you can use it for that. Otherwise, you cannot use it where you are not taking any benefit from the government. With that started that what to do with this private data. The first step was to force the aggregators of this data, the e-commerce platforms, to have the data storage within the geographical boundaries of India. A lot of opposition was there, but it was made crystal clear you cannot carry individual private data outside the geographical boundaries of India. But yes, aggregated data for analytics, you can have. You can have the mirror image of the aggregated data. And that is how it moved, and you find Amazons and banks and Flipkart kind of things having a data storage within the country. That is how it moved ahead. Then when you had more and more usage of digital data, the need came to have this DPDP Act. What does DPDP Act highlight? It has now put the whole system into a compliance mode. So compliance mode is the mandatory mode. As you are aware that if you are a holder of any private data, definitely you must have a look at this act, the DPDP Act. And definitely you have to follow that regime so that the data is well protected, the private data is not leaked, the private data is not misused. You must be reading in newspaper, some of the film stars saying that without our consent and permission, do not use us for advertising something. Yes. Yes, Aishwarya Rai. You're right. So you are reading. That's true. So that has been taken care of, that you cannot use a private data for advertising. Same will apply when your scores admission comes for IITs or medical colleges, and you have the photographs of the admission who has got. So every coaching center claiming that, okay, they have been contributed to it. So teachers know it better than I. So therefore, it is very, very important that private data without consent. The first thing you have to understand is the consent part of it. And when you are working on a DP Act, when the rules come, it becomes executionable. So we are in that zone where the act is made, but the rules are not yet out. And day is not far off when suddenly the rules will come, and you should not be caught unawares that you have not settled the regime of the compliance. The compliance may sound very difficult, like any mathematics class, but when you deep dive into it, it's very simple. It's something step by step. If you follow that as your drill, then it's like a poetry. You can easily do it, you can enjoy doing it, and it becomes a habit. And the chances of you being not compliant becomes rare. It becomes least. So that is why this preparatory session, I must compliment Arise for taking initiative to organize this and expose you to it. And then you have the INDISEC, which has done that homework as to what is they have come up with a small reckoner also as to what will help you and how you have to be prepared, mentally geared, and in your system of the school to be completely geared. You are having children on the social media also, your students, your pupils. And in social media, now in a competitive world, they are also exchanging the study material. They are also exchanging a lot of things which are concerned with the school education system. So you have to make them also aware. So you are responsible of making this younger generation aware. And of course, the compliance of your particular school or your particular organization. So you have this dual responsibility on you when you are moving ahead with this DP Act compliance. Another thing I would like to highlight before I hand over to Mr. Anup Bhasin is that when you are working with these databases, you have to have a use of, again, a digital arrangements so that the red flags come to you immediately. Because the compliance does invite heavy penalties. And definitely nobody wants to be in the trap of penalty. There will be some learning window, but after the learning window, the penalty is going to be very heavy for the simple reason that it's an individual's data which you are handling, a future citizen's data you are handling, a data you are handling who are going to be rising in the world, whose every footprint, a digital footprint is there. Their entire career, their entire study, their score, what their friend, their behavioral analysis, what you have done to them, their weak points, their strong points, everything is going to be there. Therefore, it is very, very important that you get into this regime and you do not have a compliance failure at all. And it's not difficult, like I said. And second thing which is very important is the slogan what they have given, I think they have removed that now, is the empathy part of it. You have to empathize that anybody's data, private, you have a private information of somebody, of your best friend. The best friend confides in you, believing that it is not going to leak out. Otherwise, you become a gossiper. So that confidence has to be there of the school that yes, the private data is completely protected, it is compliant. So it is not just a fear of fine for which you have to comply, it is to empathize with the thought process of DPAP that why private data is important. And future gold, they say, is a database. And in India, luckily, we are very fast on the digital track. So your financial behavior, your physical data, your scoring data, Everything you have today, a digital print. Very quick race, we have been able to reach it. All your transactions, everything has come up. So with that kind of a data, it's very important that you all are exposed to it. So I think I'll stop here, and at the end, if there are some further queries, we can address it. So I request Mr. Anup Bhasin to take over from here.
Good afternoon. It's an honor to stand before a room filled with those who shape the future, not just of students, but of society itself. As school leaders, you're not only managing institutions, you're stewarding transformation. And that transformation is being accelerated by something both powerful and personal, that is technology. Technology is not merely a support tool, but a strategic partner in education now. AI-driven platforms are personalizing learning like never before. A student struggling with fractions can now receive tailored exercises, instant feedback, and even encouragement from a virtual tutor, which never tires. Administrative tasks such as attendance, assessments, and communications are streamlined. Access has expanded. Remote learning, digital libraries, and multilingual tools are bridging gaps that once seemed insurmountable. But with this technology transformation comes a profound responsibility. Every click, every login, and digital worksheet represents more than numbers. It reflects student identities, learning patterns, and behavioral insights. It is sensitive, it is valuable, and vulnerable, which means it must be protected. So we are no longer just guardians of physical security, we are custodians of digital trust. Are our systems secure? Are we transparent with parents about how their child's data is used? Do our vendors meet the required standards? These are no longer IT questions, they are leadership questions. And when children are involved, the stakes are even higher. Children's data is among the most sensitive forms of information. Any misuse, leakage, or unauthorized sharing can cause serious harm to the child, to the parent's trust, and to the school's reputation. Mrs. Sharma mentioned about the background for enacting of the DPDP Act. So what does this mean for schools? It means taking a hard look at how student and parent information is collected, processed, stored, and shared. It means being transparent about why data is needed, seeking consent where required, and ensuring safety and accountability are built into every system in use. So compliance is not about ticking boxes or adding paperwork. It's about building trust with parents by assuring them that their child's data is safe, protecting children's privacy in the digital world, and future-proofing institutions by aligning them with local law and global best practices. Let's be honest, compliance is not the most glamorous word in education. It will not trend on Instagram. But it is a difference between innovation and litigation. More importantly, it is about doing the right thing for our students. But let me also be clear, non-compliance carries real consequences. The Act provides for penalties up to 250 crores. The greater risk, however, is reputational. So as we adopt more technology and AI in our schools, let us also embrace the parallel responsibility of data protection. The Act gives us a clear framework. Now it is up to us as educators, leaders, and guardians of the next generation to implement it with seriousness and send a powerful message to parents. Your child's safety matters to us in every way, outside the classroom and inside the classroom, both offline and online. Thank you, and I look forward to the discussions ahead. My colleague Aparna will now lead the masterclass, and we'll be happy to answer any questions subsequently. Thank you.
Afternoon, everyone. Now, since Aruna ma'am and Anup sir have already set the context, So you can just think that, we are living in a world where almost every activity, like filing a school admission form to shopping online, involves a lot of personal data, which we are sharing externally. And with this comes a greater dependence to protect that data. That's why the Digital Personal Data Protection Act is India's first comprehensive law designed to safeguard personal data, ensure accountability, and build trust in the digital ecosystem. Today, we'll be focusing or taking a brief look at the Act and what it means for us as educators and leaders, and how we can align our practices to protect that data and the trust that is placed in educational institutions. Now, before we begin the masterclass, I would request all of you to, sorry, I would request all of you to scan the QR code appearing on your screen. This code contains one question which I would request all of you to answer. Now, let's look at the result. With a student's email address. And that's exactly what a personal data means. And why can we say that a student's email address is a personal data? Because it directly relates to that identifiable individual. And through that email address, we can contact, track, or even uniquely distinguish that person, which makes it a personal data. Now, let's go on. Now, let's look at the essentials, or I would say the basics of DPDP Act in a nutshell. So, DPDP Act is not basically about locking away the data. It's about striking the right balance. It ensures that the personal data is well protected while it is being still used lawfully and responsibly to serve the educational and organizational needs. As I mentioned earlier, that personal data is everywhere, and since we are sharing it on multiple platforms, there's a high tendency of that data getting misused or breached. And once the data is breached, it also causes a loss of trust, raises safety concerns, and causes serious reputational damage. That's why this law makes it very clear that any organization, regardless of any size, must comply with this act, especially the organizations which are custodians or holding personal data of individuals or customers. Now we will look at the few core principles of the act. First being consent. As we can understand what consent means in a layman's language, is that a clear and informed permission to use someone's data by asking for their permission. So, when a data is voluntarily given or collected, if we inform the purpose or if we take the consent from them that we are going to take your data, then that forms the basis of the very first principle of DPDP Act, that's consent. Second comes your purpose limitation. Personal data, once collected, should be only used for the purpose for which it is collected. So when we obtain consent from the data principle, we are also supposed to communicate what is the use or the purpose for which we are collecting the data. And whatever purpose we state, that for this purpose or whatever purpose we are using, we need to stick to that purpose. So if we say that we want to use students' data on the school website, then in that case, for promoting the annual day or anything, then it must be used for that purpose and should not be used elsewhere. Third comes your data minimization. Data minimization focuses on collecting only the essential data, what requires and serves the purpose. Because the more unnecessary data you collect, the more risk of that data getting breached and getting leaked. So whatever data serves your purpose, you should only collect to that limit. Fourth comes transparency. Transparency is basically being clear and open and honest about what data you're collecting, how it will be used, how long it will be stored. Parents and students should never be left guessing that why and how and for how long the data is going to be used. And once there's a clear communication and transparency, that also builds a strong trust between the school, parents, and students. Last being accountability. Accountability over here is all about ownership. The school must accept responsibility for protecting that personal data it collects, even if it's processing and sharing it with third parties, because we understand that a lot of students' data might be shared by schools with third party vendors. So it is also very essential that when data is shared to third parties, schools are fully accountable and take the full onus of sharing that data, and any subsequent breaches that happen owing to a negligence on the part of the vendor, they need to be accountable for that as well. Okay. Now, as you can see on the screen, what are the risks of non-compliance? So, non-compliance with the DPDP Act can lead up to penalties of almost 250 crores. But fines are only one part of the impact. The other impact is loss of your reputation, and of course reputation damage with your parents, students, for even organizations for losing out on their customers, clients. And alongside this, there's also operational disruption. So what do we mean by operational disruption? When there's a breach, data breach, the IT teams will be involved in, investigations, legal process, and system recovery. Hence, the true cost of neglecting data privacy is much higher than just monetary penalty. Now we'll focus on Section 9 of the DPDP Act, which speaks of processing children's data and how children's data must be handled. Since children are considered as the most sensitive group of the society, hence the law puts special protections in place to safeguard them in this increasingly digitally active world. So, what are the key aspects of that section of processing children's data? Obtaining verifiable parental consent. As we all know, children are minors, and anywhere we go, they always have to be accompanied by a guardian, be it opening bank accounts or anywhere else. It's the same thing the law places here. Whenever a child's consent is being taken, it has to be not just a child's consent, it has to be actually the parents' verifiable consent, which the school or any organization has to collect before processing any child's data. Second being, the Act strictly prohibits tracking, profiling, or targeted advertising directed at children. This protects children from digital manipulation and ensures their online experiences remain safe and age appropriate. Then third is higher safeguards. Schools and organizations are expected to apply stricter safeguards measures like strict access controls, parental consent before sharing data. It also involves encryption of digital records, conducting regular audits of third-party apps or vendors when handling children's data. So whether it's your admissions, your CCTV footage, or educational app, there needs to be a high safeguard which needs to be placed in them. The basic idea behind this is to protect and reduce risks and protect children from harm of misuse of their data. Now, why this matters for schools? Because for schools, it's not just compliance, it's also about building trust with the parents. When the families know that their children's data is being handled responsibly and safely, it strengthens the reputation of the institution and aligns with the duty of care as educators. So I will explain this through an example. So, for example, the school uses an app to assign homework, and this app subsequently collects the child's name, age, or even sometimes location. Under Section 9, this will not be permissible until and unless you have a verifiable parental consent. Also, the app can never use that data to show ads, or track the child's online activity. Now, why do we think children's data is different? As we all know, that children today are extremely digitally active, be it from online class to learning apps, they are constantly leaving a trail of personal data. But unlike adults, they are legally dependent on their parents and cannot fully comprehend the risks of misuse of such data. What makes it even more serious is that if a data is leaked of a student, a breach of child's information today could harm their opportunities, safety, and well-being for life. And this has been, and UNICEF's 2021 report also found out that children are 3 times more vulnerable to suffer from long-term impact from online data misuse. That's why the law places special safeguards on them through Section 9. Now we'll look at how a day, what consists and what makes up a data life cycle. So to begin with, first is collection. Data starts at the collection stage. The DPDP Act, as I mentioned earlier, requests to collect only the data that is necessary and relevant and nothing extra. Then second comes sharing. So the next stage is sharing. So if the child's data is passed on to third parties, say your external transport vendors at school or an educational app, it must be only done with proper consent and stated purpose. As I said, that consent is obtaining verifiable parental consent, and purpose being the purpose for which you want to get that collect that data and process. Third is lawful processing and transparency. When data is being used, the DPDP Act stresses on the principles of lawfulness and transparency. So what do we mean by lawfulness? Schools must only use student or parent data for clearly defined purposes. And second, transparency. Basically, parents should know how, why, and where their child's data is being shared. There should be no hidden secondary uses. Then comes storage. So storage, as the name suggests in itself, is how and where the data is being stored. So data must be kept secure with safeguards like access control, encryption, and policies. And it shouldn't be stored forever. Retention should only be there as long as it's necessary. For example, if you're keeping old students' records without any purpose or reason, it will only add to your risk of getting that data breached and simultaneously violates your principle of storage, wherein data should not be retained beyond its purpose. Then fifth is deletion. So the final stage of data life cycle is deletion. When the purpose is served, data must be erased. And individuals, including parents, have that right to request deletion. This is where accountability as an organization or an institution comes in, wherein they must prove that they have processes in place to responsibly close the data life cycle. Now we'll look on to some of the examples of cyber attacks on Indian education sector. So as you can see on your screen, between July 2023 and April 2024, the education sector faced over 2 lakh cyber attacks and more than 4 lakh data breaches. What's more alarming is that schools are 5 times more vulnerable compared to global peers, largely because of their weaker hygiene practices. And thus, it makes schools a prime target for attackers and also highlights why strong data protection measures under the DPDP Act are not just legal compliance, but a necessity for safeguarding children. Now, we'll focus on a few case studies that happened in India with respect to data breaches. So, as you can see, in August 2025, in IIT Roorkee, personal records of nearly 3,000 students and alumni from IIT Roorkee were found exposed online. The data reportedly included contact details, caste category, academic scores, and even financial aid records. The information was accessible for years due to poor server configurations. And what was the impact? Risk of identity theft and targeted scams, loss of trust among alumni and students, reputational damage to a premier national institute. In this case in particular, a ransomware attack hit the admission vendor. Hackers sent fake fee requests to parents, putting both money and trust at risk. Families were tricked into paying false fees, trust in schools eroded, and sensitive admission data was exposed. Now imagine if this would have happened if the DPDP Act was implemented. The institute couldn't say that it was the vendor's fault because the responsibility for data doesn't end when you're sharing it with a vendor. Even if an external processor mishandles information, the liability stays with the school or the organization. In short, you can outsource your work, but you cannot outsource your accountability. So what do you think could have been a compliance risk in this case? School will always, or the institution will remain liable for the vendor breaches even if proper due diligence and safeguards weren't ensured. Penalties could reach up to 250 crores along with your reputational loss and operational disruption. So if your vendors aren't secure, contracts, audits and monitoring are your safety net. Now we'll look at a case study at a global level. So this school in Iceland was fined approximately 9,000 euros under GDPR after a teacher accidentally emailed sensitive records of students, including health and social details, to the wrong recipients. This pointed to a very critical point under data privacy laws that even an accidental mistake like sending data to a wrong person is seriously treated under data protection law. Hence, laws expect schools to have preventive safeguards like training, secure systems, policies in place to reduce the risk of human error. Now we will look at that what can go wrong if schools don't protect their students' data. So first is harm to students. Like if a child's data is stolen, it can be used to open bank account or commit fraud in their name, and this risk can follow them for years. Cyberbullying and deepfakes. Misused student photos or videos can be turned into fake content or used for online bullying. And this causes not only long-lasting reputational, but also emotional damage to the students. And apart from this, there's an emotional trauma that anyways the students will be facing because of a misuse of their personal data, ultimately shaking their confidence, mental health, and sense of safety. Then comes loss of trust and reputation. So first begins with loss of parental trust. If parents believe that their child's data isn't safe, they may choose to withdraw themselves from that school. Second, a negative media coverage of a breach can overshadow schools' any amount of achievements. And lastly, being admissions will get impacted. As you know, word of mouth spreads fast. So future enrollments may drop if schools are seen as careless with data. And as the last one focuses on financial and legal trouble. So you know already there are hefty fines under the DPDP Act, and schools can face the same steep penalties for failing to secure that data. Then there's a cost of recovery, that is the investigating a breach, restoring systems, managing communication with parents, which can prove to be expensive in the long term. And vendor liability, even if a breach happens through a third party or a social app, the school will still be held responsible under law. So a single breach can ripple out into academic, financial, and reputational damage, making prevention absolutely critical. Now, This slide focuses on a blueprint that we have prepared for schools to follow and act on the DPDP Act. So this blueprint steps has been divided into 5 parts, as you can see on your screen: C, A, R, and in the next slide we have the other 2 aspects of it. So let's begin with C. So what you can do as an institution is you can collect and map student data. Now that since we know that why it is important to protect student data, let's now focus on a practical, easy to follow framework. So C begins, as I said, collect and map student data. The first step is to clearly identify what data you are collecting, like marks, photographs, medical record, IDs, anything that relates to your students or parents. Second, you need to track where you are storing that data, whether it's on paper files, in school management systems, or cloud platforms, and who has access to that. And mapping the data helps you to understand potential risks and ensures that data collection is purposeful and limited to what's needed. Then A stands for ask for parental consent. Parental consent, again, is a cornerstone of compliance, especially when dealing with children's data. Consent must be clear, informed, and verifiable. So whatever forms, like admission forms or any forms that you use in your schools, should be simple and written in a language that parents are able to easily understand. And consent must be clear, informed, and, as I said, verifiable. And consent should never be assumed. It always needs to be asked and documented. R stands for reviewing and securing your vendors. Since schools work with many third-party vendors, bus operators, online portals, fee apps, etc., these vendors may have access to student data. So, what schools can do as a part of exercising their accountability and responsibility, they can conduct audits to ensure that these vendors follow data protection guidelines, and you can include data privacy contracts as well. Your school remains accountable even when you are working with outsiders. Now, the E part of the blueprint stands for educate staff and engage parents. Everyone in the school community plays an equal role in safeguarding data. So training your teachers, administrative staff, and even students on the best practices for safe data handling can do much more than not training them or keeping them in the dark about data privacy practices. You can also create channels where parents can easily raise their concerns or voice or ask questions about how their child's data is being used. S, as you can see, stands for stay breach ready. Even with strong precautions, breaches can still happen. That's why having a breach response plan is extremely important. Once you have a breach response plan, you need to practice it regularly, just like a fire drill, to ensure everyone knows what is their role to be performed during that incident. So, if your school cares, your students are safe, your reputation is strong, and parents will trust you more. Now, this slide highlights what are the 4 values that are driving behind our blueprint model that we have termed as CARES. First is respect for children's rights. Students' data, as we all know, is not the property of the school as such, but it is also the property of the child. Schools are custodians of that information, holding it in trust. Just as schools take responsibility for a child's safety on the campus, they must also safeguard the child's digital safety. Mishandling data is as serious as neglecting physical safety. Respecting will always means, is this in child's best interest before collecting or storing their information? Second is compliance and training. Data privacy is not just about drafting policies or just filing them away. Real compliance comes from awareness and action. Every teacher, clerk, IT staff member, and even bus contractors must understand the basics of handling students' data safely. One untrained staff member can accidentally cause a breach. For example, sharing a class list on WhatsApp or leaving files unlocked. Regular training will ensure that data privacy becomes a culture and not just a checklist or compliance. Third is strong safety measures. Protecting digital data requires, as I said, same seriousness as protecting school gates. Locks and guards keep children safe physically, while digital safeguards such as strong passwords, restricted access, firewalls, and encrypted storage protect them online. A lapse in either exposes children to harm. By investing in secure systems and processes, schools send a message to parents that their trust is valued and protected. Last being clear and fair use. Collecting student information must always be, as we've emphasized earlier, purpose driven and transparent. Only ask for data that is genuinely needed to deliver education or ensure safety. For example, if you're collecting a child's medical condition data for health emergencies, that seems justified. But asking for like detailed family financial data without a clear reason can create some suspicion in the parent's mind. And since parents have the right to know why their data is being collected, so it's all the more important to have the purpose clear in mind before collecting the data. Overcollection or hidden users erode trust and may invite regulatory scrutiny. So, data privacy in schools is about trust, protecting children's rights, training your people, securing your systems, and using the data fairly. Now that we have emphasized and seen the CARES framework, a natural question that must be coming up in everyone's mind is, where do we start? What are the steps that we can take to begin with our compliance journey with the DPDP Act? So this slide is designed keeping that in mind, that what are the some of the steps that schools can take with immediate effect to ensure that they are somewhat compliant with the DPDP Act. So first being training and awareness. So it is essential that everyone in your school, teachers, admin staff, and support staff understand why data protection matters and what rules apply. Training sessions and awareness programs will lay the foundation for the same. Second is gap and risk assessment. The next thing and the most critical part is getting your existing system reviewed. Map where your personal data is stored, how it's used, and identify areas where you're exposed to risks, both operational and legal. Fourth being plugging the gap. Once the gaps are identified, which you will be able to identify after conducting a gap and risk assessment, you will need to implement necessary safeguards. And this will include revising data collection forms, vendor contracts, and putting in place secure processes for data handling. Fourth, being ongoing compliance. As I said earlier, data privacy is not just one time activity. Continuous monitoring, audits, and preparedness for breaches are crucial to stay compliant and build trust with parents. Hence, with these 4 steps, you will be equipped to move forward confidently and ensure your school is safe and it's a trustworthy place for students and families. So now that you people have already had a sound understanding of the Act, its implications and requirements, we have created a short quiz for you, which we'll have a QR code, which I request all of you to scan, and please poll your answers. So again, the majority wins. A student's email address is definitely considered as a personal data. Let's have a look at the second question. Okay, here again, the audience wins. So again, what the school's wide announcement of class 10th exams is not considered a personal data. So that's quite impressive that the audience has actually understood what personal data is all about. Okay, now now we all know. Now since you people have covered since we have covered a lot of ground today, and I know after this masterclass there must be a lot of points which must have sparked a lot of questions and concerns as to how they apply in your own environment or your own schools or organizations. Hence, this is the perfect time to raise them. If it's on your mind, please feel free to ask.
Yes, ma'am. Ma'am, can I ask? Ma'am, since I'm handling social media platform of the school, so there we post pictures of various students, the activities being performed during that period of time. So, do we need a consent on this, or could you just throw more light on this? It's acceptable
Yes, it is acceptable, but before that, you will have to seek fresh consent.
for every time, or we can take it annually one
Annually, it is
annual.
practicable. Practical.
Okay, for that session.
Yeah, you
Okay.
can have a consent form where you can list all the activities that you take, and you can seek parental consent annually.
Annually.
Yeah.
Okay. So it will be applied to all the social media platform as well, like prospectus or maybe our newsletters or school magazines, where we definitely put our pictures of the students and activities which are being
Yes,
performed. So all will be
everything
covered
is
under one
acceptable.
consent.
Everything is
Thank you.
Yeah,
Thank you.
here
Yeah.
I'll just like to add, anyway, you will have an access restriction to your social media data. Only those who you give a password, like whether they are accessing your newsletter through the email address or they are accessing through any other social media, it should not be an open house. So you can use that rider of a password for those who allow access to seek into whatever you're posting in that data besides the consent what he rightly told you. No, it cannot be a public page. And school advertisement, if you are using somebody's photograph, then definitely you have to take a proper consent. Your high scorers to attract next year admissions, then you'll have to take.
Ma'am,
So
what
here
would
you
be,
can have an access based restrictions. You can have a password.
ma'am, what would be the legal definition for verifiable consent? Is it just a written signature or something? Verifiable consent.
You will have to see whether that consent is coming directly from parents of that student. You can have your own mechanisms for verification, whether through video calls or in person.
Yeah, yeah.
Excuse me?
Generally, all the schools have a web page, and where you have an access to the students. So whenever you are using, put a question there. Like
I
she
have a
put
question.
a QR code for the question, you can put that.
I have a question. I have of a child who has already taken the TC from the school. So I think on the TC we do mention the PAN number, the Aadhaar numbers of the parents, all necessary details which are there to be on the TCs as per the format. So is it not kind of a breach of the data? Because one may say that admission numbers are not known, but if I know just one admission number, so if I really want to breach the data, I think I will just use a hit and trial method and get a lot of things. So one thing I really wanted to mention, because we found that one TC was there on Google. I don't know how, but there was some kind of a hackers who used that particular TC to be uploaded on Google. If you find it there, the Google will give you the answer that that TC is there and if it was available publicly. So it is, I think, a kind of a high risk for this as well.
Yeah, I'll answer it. I'm Prateek. I'm a lawyer by profession and founder of INDISEC. So there are twofold, apprehensions which is coming. First, coming to your question. So government identifies in this act that there are certain things which has to be done and which comes under the legitimate use policy. So for any mandate of the government or for any directions of the court or any requirement from an authority, without having a consent as well, you can share that. So you are asking that if you have to put the transfer certificate on a mandate of a CBSE, so that comes under the legitimate use. So it doesn't mean that the school gets fined on that. The previous question which came on the social media, so the situation is not going to come where for each activity you will have to take a consent of a child. So first we have to understand, so far as the consent of the child is concerned, it comes with the verifiable consent of the parent. And the verifiable consent means that it should be verified that the person who is giving a consent should be a parent or should be a guardian of that board. Once you obtain it, so the consent, the act says it has to be clear, unambiguous, purposeful, and it should state that which all activity you are taking the consent. Now the government, as per the act, is very, very clear, especially so far as section 9 is concerned with the children, that the schools has to be very careful that they don't track the behavior of the child. The whole act is cornering around that in terms of violations of child data. All the FMCG companies, all the other institutions, they are trying to predict the behavior of the child. That is what government also want to restrict through DPDPA. So you have to be careful once you have a consent. Then also you should not give any information which predicts the behavior of the child, which tracks the behavior of the child.
Actually, my concern was not that school will be penalized or not.
I'll just respond to you.
Yeah, ma'am.
10th and 12th results, right? It is on a web page, but they are protected. Like I can't see your result, you can't see my result. So now with the DPDP Act coming and the rules coming, CBSE, the mandatory putting a TCS, your transfer certificates on the website will have to give it an access code. So there will be like an OTP, like if I want to access my TC from a particular school, there will be an OTP where I can have an access.
No, I think you have taken it in a wrong manner, because the TCs are uploaded not just for the child or the parent. TCs are uploaded for other schools where the child will be taking the admission. Yeah.
That school will also exercise it.
This is not about whether the school will be penalized or not. The concern was that there is a data breach or not. There is, I think. Everything is there online.
Yes. No. Going online is not data breach. Access to that data by somebody who is not concerned is a breach.
That is what.
Right. So that correction CBSE will have to do. Let me flag it very clearly.
Thank you.
The moment this act and the rules come, that correction will have to be done. Right? Got it?
Well, when it comes to data, this thing, looking into the numbers and taking that kind of, consent, is an opt-out model viable, wherein we tell the parents that if you are not interested in your children being featured on social media posts, you can give us an application and we will opt out. And if you don't receive your application, then we are taking it as that you are okay with.
That's a negative form of taking a consent. Rather, it should be in a way that all the children whose data come to your organization, to your school, it should be preceded by a consent form, and which charts out all the activities which you are going to do. Let's say for an academic year, you are not going to go back to the parent to take consent on everything. Even if it's a blanket this thing, but that has to be clear and unambiguous as per the act. It cannot state that you are taking a consent for a specific purpose, let's say X, but you share the data for the purpose Y. Then you come under the non-compliance. If you have taken a consent for X and that may be number of activities, then you may process that data because you have a valid consent for that.
So there's
also one more
one
thing, sir.
important thing that I can point out. We are coming up with PEN. That's the permanent education number. If the same theory that we adopt as the OTP for the Aadhaar, if that is done each time somebody wants to get into the account of a child, the child would get one OTP and the child has to verify that. So I think we are moving in the right direction, and this PEN is going to do away with a lot of problems with regard to data protection.
That will add to the layer of security.
Yes.
Also, sir, what about the vendor's responsibility of making sure that the school has multiple vendors on board for multiple services. So is there any accountability of the vendor also, or it ultimately boils down to the school?
So the first accountability comes to the school. They have to, because when you operate with a vendor, you get into a certain kind of agreement. So now those all agreements need to be revisited with the clauses of DPDPA and with the indemnity going with you, and also cautioning them that they will be processing that data based on these all formalities which are required by the Act. So the first obligations come on the school, and then the second liability comes on the vendor if he breaches that.
Sir, is there any consent form which is laid down in DPDP which to be used by the schools, or we can frame our own?
So every organization will have to frame their own, because the activities pertaining to taking the consent may be different. But there is a broad outline which has come in the Act, as I mentioned previously, that it has to be clear, unambiguous, specific, purpose-driven. And also there is a schedule which has come. Now one more obligation I'll tell you, and I think most of you will feel scared for processing and taking the data, that now industries are being classified with the government, and the schedule is coming that once you take a consent, once you take a data, it is not forever. So if a child has passed out and there is a schedule which says that the schools has to delete that data, now the burden of deleting the data comes on the school. And if you don't delete it within a specified time, you are in the non-compliant tag. So this is, see how the GDPR evolved globally, how the Singapore data privacy laws, how the California data privacy laws evolved. India is seeing that. And with the genesis of Puttaswamy judgment from Honorable Supreme Court, which came through 9 judges bench, this law is very clear. So I'll tell you one more intent of the government, that the government has parallelly created through this statute a court, Data Protection Board of India, which has all powers of a civil court, and the appeal goes to the Telecom Appellate Tribunal and then directly to the Supreme Court. So there is no High Court involved. So government is very clear, you either follow the law or get penalized or close your business. So that is how, the big work in terms of data protection, privacy, and respecting the data is coming in India.
But then, when you are speaking about data deletion, I'm sure many of my colleagues from various schools may have faced it, is you don't know at what point of time, because in India, all the criminal cases specifically, their date of birth is validated from the school.
Very well.
So you have requests coming at all odd hours of children who may have passed out 20 years back, 15 years back for us to produce, if that person has put up our school's name. So when you're talking about, I'm sure then that provision is also there, that the school is not liable to keep data
then
beyond
you come
it.
under legitimate use, which I just pressed upon. You work under that mandate. It is not that you have deleted the data and the court asks, regulator asks, government asks, police asks, any authority asks, and you cannot give. Your advisor will tell you, you are covered under this and this clause, which is a legitimate use policy, and you can process it.
So what is the deletion period? Is it being mentioned?
It is about to, so the act has come in 2023. Now the notification is expected anytime soon. Last week, Honorable Minister of IT and Electronics has given his statement to Money Control that before the next Parliament session, they are going to notify the rules. And the consultation has already been seized on 5th of March. Ministry of Home Affairs has already given their approval. So we are expecting in next 30 days, it is going to be notified.
I have 2 questions. Are there any
Schools
government...
will be getting some kind of a circular on this?
Excuse me?
You will get a proper notification on the act. I'm sorry.
I have 2 questions. Are there any back-end processes where the government is accrediting any auditors to help with these processes? And second, if we do find a problem, for example, if I have a problem with the school misusing my child's data or sharing my numbers with random coaching institutes, for example, that actually happened to me, what remedy can I go for?
So if you feel that your right to privacy has been violated, you will have a court in India that is called Data Protection Board of India. So you can write down a complaint that has a statutory powers of a civil court. So from 10,000 rupees to up to 250 crores, they can penalize seeing that which section has been violated. So that is a legal remedy with you. And I think first question which you asked.
Is there any government accredited auditor or body being put in place whom we can contact to come audit us and certify that we are doing it right?
Yes. So data audit now, a lot of firms have started doing it. There is no accreditation, but people are getting registered. Like INDISEC also does data audit, but we are taking help of AI and tech because the reality is that you are dealing with data of millions of people. It cannot be done manually. So
Sorry to push the question further, but I've had this same issue as well. I've had a data privacy audit done, in fact, a much broader one. And the first thing that the auditors ask is for pervasive access to the system, a root level access or a system level access. That itself is a breach of the data we are trying to protect. So it defeats the purpose of using such an auditor. So unless somebody is accredited and knows how to do the audit,
you must check at least the registrations with the concerned ministry. That the data auditor should have that, and now there are certain registrations happening with Ministry of Skill as well.
Okay, thank you.
It's like internal auditor, he cannot share the data with anybody, but he can access in your system to give you a good feedback. So
May
he'll
I?
be working on those principles.
Right now.
Like, I have worked in Doha, Qatar for 4 years, leading international setup school. What we were doing there, because it was Mohammedan country, so there were certain restrictions by the communities. What we were doing there, we were having admission and registration form explaining all the rules, regulations, and privacy acts, and parent was supposed to sign that with yes or no. Like if they want the photograph of the student in different activities to be on the social media, they have to write yes, otherwise they can put no. So that kind of system, having all the clauses in admission form or in registration form, can we apply here now onwards?
Yes, now consent form can be attached to an admission form that will spell out the specific consent, or maybe if they want to opt out of it.
And students, those who are already admitted, I mean the old students, those who are in present session, we can have special consent
Now
by
fresh
sending
consent
them.
has to be taken.
Right, thank
After
you very
notification, fresh consent has to be taken for any type of data process.
Thank you.
Just one question, please. Okay, is there somebody else asking a question? Okay, I just wanted to ask one thing. We live in the age of social media and we do share reels of what our children are doing in the classroom. We do share weekly newsletters with our children, okay, and with our parents. If the parents put that on status and they share it further, is the school accountable there?
No,
or are we not?
No, see, let me tell you, the IT Act presently, which is in force, says so that you cannot share the data without any consent. Specifically, the IT Act, in which photographs and reels and everything is covered. But that has not got us great enforcement like the DPDP, which is coming in because of the penalties. So this comes under the third party. If you have given it to somebody else and that person has shared it further, then the liability comes on that. But you need to have agreement in place where there is a explicit consent on sharing of data only on the basis of first you are having the consent and then you are sharing the data, and then in case anything happens at the vendor side, at the vendor's hands, then he should be held liable. So there should be indemnity clauses.
No, but we've been clearly told that we are accountable.
Sir, there are two things.
So first accountability comes if you don't have a consent for it.
So there are two things that I want to point out, that in the middle of all this discussion, where we are reaching is that we are trying to fix responsibility.
Correct.
If there is a breach, we have to find a method how that breach has to be blocked, whether it is at my end or the vendor's end or anybody's end, because nobody is doing it deliberately. So it is the intention that's more important, and we should have regulations or systems in place where intentions are measured rather than the acts that happen.
So let me tell you one very interesting thing. Under this act, the penalty doesn't come on the breach. So I think the regulator, the government also understands that we are a country of 140 crore people and a breach can happen. But on a breach, what obligations you have to do, what work you have to do. If you don't do that, then there are consequences. So that is there in the act. Yes. So tomorrow, if you're there, INDISEC is releasing a handbook. Specifically, it's called a privacy booklet for schools. You can get your copy tomorrow. It is going to be released. Yeah, that is going to be released by the hands of Honorable Minister. He will be there. So it is jointly released by FICCI, ARISE and INDISEC. that covers exhaustively that what schools have to do specifically for the children's consent and data and subsequent. Yes, that includes all the paperwork, the knowledge work which you have to take care.
Is it available online also, ebook after
No, but
its release?
it is to be released tomorrow. Once after release, we will share it with all. I think our team is there, so we can exchange the numbers. We are taking responsibility of sending it to all the Arise school members, and you will have a copy with you.
Wonderful. Thank you.
Yes,
you
yes.
go about with it in case a breach happens.
That
would be
covers
really
that.
helpful.
That
Thank
covers
you.
But if you have a consent for tracking, then you can do it. That's not a behavioral tracking. You're tracking child for the purpose of safety. But if you're sharing that data for that particular service, if you have a valid consent for that, then there is no breach. No, but for that, if as a school you are having a valid consent, even till the last child is there. So let's suppose that the last child goes at the last point. If that child has given a consent, he is being tracked, then there is no issue. Then there is no breach. So we are expecting that in rules they will give a schedule that the consent for the schools pertaining to child will have the consent will have a applicability for so and so much time. So what will be clear once next month maybe this rules gets notified.
So the question is that because schools also take children on trips, right? And there is a consent made for the same, which is for the school with the parent, right? But when they go on activities like rafting or safaris, there is also a consent required at that point of time. And those organizations also require the school or the teacher to make a consent. Now it has to be done, and they want that their name should also be mentioned in the consent form to give them that exemption. So what happens in that case, sir? Because then there is a conflict between the school and the parent and that organization. Each say that why should we be refilling this form again and again? Now who and what should be the process there, sir? I mean, any answer?
So it, like I previously mentioned, for every activity you don't need to take a fresh consent. Once you take a blanket consent, but charting out all the activities, even for the outstation visits, for sports activities, that has to be there in the principal consent which you have taken. So any vendor you encounter during the course of the year, you just have to get into a paperwork with that vendor, and you don't need to take a fresh consent every time you do any activity.
And to your question, hold on. What the rafting person is taking is the indemnity bond. What you are taking is a consent form of parent that, okay, your child will be put to rafting. So that risk is inbuilt there. But the operator, whosoever is doing, that's the indemnity form. That's entirely a different thing.
Ma'am, so who fills that? So
That is taken by the rafter because he is taking indemnity against the accident of being not responsible in case something goes wrong. Right?
Since these are minors, since these children are minors, someone will have to sign that.
It will be the teacher or the parents, adult. Some adult has to endorse.
I have a question here. Is this covered under the ambit of data? I mean, this is just a consent for doing that activity or not. This is not related to data. In this
That's what I distinguish between indemnity
Yeah.
and the consent for the data
Exactly.
stored.
So related to this only, like we were talking about tracking the behavior, very often, like on various points, schools do collect the responses to certain questionnaires related to their school satisfaction or to certain other areas of school functioning. And they use that data to analyze, and it is published also at certain extent, does that gets covered under the ambit of data protection?
That 100%
because
gets
it is
into
tracking
DPDP.
behavior in
Yes.
some format.
Because you are taking a decision, maybe it can be a financial decision, marketing decision, or sales decision on that behavior of a child. So the Act specifically says that if you are restricting or tracking the behavior of the child, then you will be penalized if there is not proper following of DPDP.
So I'll make it more specific. So school did some kind of an event, or let's say year-end survey, which has got number of questions related to the academic understanding, related to the infrastructure, and based upon that analysis, school publishes a report of this parent satisfaction or a student satisfaction. So it means that is covered under the data protection.
Yes, because you are taking the name, email ID, age, gender of that child, that is a personal data as per the Act, and you are basically going to share it with somebody. So if you have a valid consent for doing that, then you can do it.
So it means when that survey questionnaire is compiled with the consent.
No, just hold on. Any survey you do on your mobile also you give, it asks your consent first. That you want to be a party to that consent. So it has to be a part of survey form, what Pratik has rightly said. But aggregated data, right? You're just aggregating that 20 people say your classroom size is not good, your benches are broken, or your mic system doesn't work. So that aggregated data you are using for analytics. So that is a different set altogether.
She did it, analysis is allowed.
Yeah, where you are not specifying to a particular child that A parent said the bench is broken, right? Or a child, B child complained XYZ, that you are not going. You are just analyzing the aggregated data. But to collect that, what Pratik rightly said, you will have to get a consent for that survey form.
I see.
Right?
Yeah. Thank you.
So I have one question. This is regarding the retention of data. We were talking about you can't retain the data again, it's breach of data. Now, when a student comes after 10 years or 12 years, this is regarding CBSE, wants to change the name and then goes to CBSE, CBSE again tells back to the school that you got to submit everything to us, including the admission form, the AWR, which we have the admission withdrawal register. If we delete the data, how do we submit and how do we help the child?
See, again, it is under legitimate use. So some data, let's see what schedule comes for the schools. I'm hoping that for schools specifically, at least they will have a longer period to retain the data. But that sharing also goes with consent if it is not under the legitimate use. If CBSE is not asking, some other person is asking, who's an private person, then you cannot share the data unless and until there is a explicit consent on sharing that data to a particular person. So if a sister of that ward comes that I have a specific authority that I take this and there is a consent to that, then you can share that.
Definitely CBSE. It's just about the time duration I'm talking about when you're talking about deleting the data. So there has to be some time duration and timeline.
Hey, that will come in the schedule. Plus, you have to decide what is like a permanent data and what is a temporary data. My class result on class A may be useless, right? But the day I got admission, the day I left the school, right? What date of birth was written, all that may be very important. So it's like permanent data and a data which will come under this, which has to find an end date, sunset clause has to be there.
Sometimes, ma'am, the companies whom recruit our students, they get back to us for verification. And in that case, they mark it confidential. Are we supposed to first take a consent of the student, the alumni, and then fill it up?
Certainly.
Okay.
Yes. Thank you so much.
Yeah, you are right. All recruiting company does that. You'll have to take a consent that, okay, you're sharing, the employer also will do. You're sharing the data with XYZ, right?
I think we can now take it one on